special invitees who are present in person or online. The Honorable Mr. Justice Adrian Saunders, President of the Caribbean Court of Justice, and the Honorable Judges of the Caribbean Court of Justice. The Honorable Mrs. Justice Marva MacDonald Bishop, President of the Court of Appeal of Jamaica, and the Honorable Judges of Appeal. The Honorable Mrs. Justice Zayla McCalla, former Chief Justice of Jamaica. The Honorable Mr. Justice Seymour Panton, Chair of the Integrity Commission and former President of the Court of Appeal of Jamaica. The Honorable Mr. Justice Patrick Brooks, former President of the Court of Appeal of Jamaica. The Honorable Miss Justice Hilary Phillips, distinguished former Judge of Appeal of Jamaica. The Honorable Mr. Justice Ian Winder, Chief Justice of the Bahamas. The Honorable Madame Justice Yonette Cummings Edwards, Chancellor of the Judiciary of Guyana. The Honorable Mrs. Justice Roxanne George Wiltshire, Chief Justice of Guyana. Honorable Judges of the Supreme Court of Jamaica. Miss Marlene Aldridge, Solicitor General of Jamaica. Dr. Tomlin Paul, Deputy Principal of the UWI Mona campus. Dean Ali and of the Faculty of Law, and Deans Taylor and Ricketts, Faculty of Science and Technology and the Faculty of Social Sciences, respectively. Professor Marcia Roy, Director of Graduate Studies and Research. Dr. Halima Deshong, University Director, Institute for Gender and Development Studies. Ms. Eulalie Greenaway, Senior Tutor, Norman Manley Law School, and our colleagues at the Norman Manley Law School. Principal of the Eugene Depuch Law School, Principal Bastian Galanis. The Honorable Dr. Lloyd Barnett. The Honorable Michael Hilton, King's Counsel. Mr. Peter Golson. Honorable Patrick Robinson, former Judge of the International Court of Justice, and other family members of our inauguree, fellow colleagues of the University of the West Indies, students, ladies, and gentlemen. Good evening. My name is Celia Blake, and I am the chair for this inaugural professorial lecture being delivered by our very esteemed colleague, Tracy Robinson. It is customary in the Academy to observe and celebrate a colleague's elevation to professor, the highest academic rank, by way of a public lecture. Having been promoted to this rank in 2022, Professor Robinson will this evening publicly mark this achievement in her career with her lecture, which she has alliteratively titled, A Caribbean Common Law in Flux, Imagining a Future for a Fuzzy Legality. I'm delighted that you're here, whether in person or online, to celebrate this significant and special occasion with us. And I don't think I have to assure you that Professor Robinson has in store for us an engaging talk that will raise questions that you will be mulling over, I'm sure, for some time. So at this time, I invite the Deputy Campus Principal, Dr. Tomlin Paul, to say a few words and greetings on behalf of the campus. Deputy Principal. You can use this.
Thank you very much, Dr. Celia Blake, our chair for this evening, Professor Shasida Ali, Dean, Faculty of Law, Professor Tracy Robinson, our distinguished speaker this evening, and family members of Professor Robinson, distinguished judges, guests, colleagues, and students of the UWI. It is my great pleasure to bring you greetings this evening on behalf of the campus administration here at the University of the West Indies, MoNA. Our principal, Professor Denzel Williams, sends his apologies as he's traveling on university business. And first of all, I wish to extend heartfelt congratulations to Professor Tracy Robinson on reaching this significant milestone in her academic career. Professor Robinson, it is indeed a very happy day for our campus as we celebrate this achievement with you, with your family and your colleagues. An inaugural professorial lecture is a significant event in the life of any university. It marks the formal recognition of a scholar's promotion to the highest academic rank. and it provides a platform for the sharing of their intellectual journey, their contributions, and future vision. These lectures are a testament to the values of academic excellence, thought leadership, and the relentless pursuit of new knowledge. All of these are values, colleagues, which we hold in very high regard here at the University of the West Indies, Mona. Professor Robinson is indeed a distinguished legal scholar and a thought leader whose work has had profound impact on Caribbean jurisprudence, human rights, and gender justice. Her work exemplifies academic rigor and insightful perspectives, visionary thought, and resonates not only in academic circles, but as any good scholar, the work of any good scholar does, it resonates within the wider Caribbean, and I also say globally. This evening's lecture, A Caribbean Common Law in Flux, Imagining a Future for Fuzzy Legality. Quite a, one may say, a sexy topic. Yeah? Not sure if that is legally correct. But it's a topic that is both timely and relevant. Our region is continually grappling with complex legal landscapes that call for innovation, inclusivity, and adaptability. We thank Professor Robinson for her dedication and work in this field, and look forward to this discourse as she continues to serve the region by strengthening and shaping both legal practice and education. We are delighted to see our campus continuing to contribute in this manner through the work of our scholars such as Professor Robinson to regional, national development, and indeed making that impact globally. Once again, on behalf of the University of the West Indies Mona campus, I congratulate Professor Robinson on this significant achievement, and we look forward to the rich insights she will share with us this evening. Thank you.
Thank you very much, Dr. Paul. I now call on Dean Ali to formally welcome you to the Faculty of Law, which of course is the host of this event. Dean Ali.
Thank you very much, Dr. Blake. It's really an honor for me to stand here this evening, and I'm truly delighted to welcome all of you to the inaugural professorial lecture of our esteemed and dear colleague, Professor Tracy Robinson. I am truly delighted to welcome so many of you here in the room in spite of the inclement weather, and those of you who I know are watching us online. Many of you may not know this, but I take a personal sense of pride in sharing with Professor Robinson today because we began this journey on the same day, and I see a couple of our other colleagues. So it was just a few years ago, right, Tracy, that we sat in a little room somewhere on this campus and began the journey, a journey that Professor Robinson, truly excelled in. And so she so much deserves this. And so it's really with a tremendous sense of pride and joy that I'm here to welcome you. And I know you're all eagerly anticipating her lecture, so I won't be long. Professor Robinson, of course, is an expert in many areas of the law, including constitutional law, public law, and family law. And so when I look at the title of her presentation, A Caribbean Common Law in Flux, Imagining a Future for a Fuzzy Legality, I am truly intrigued, and I am waiting with anxious anticipation to hear Tracy. So once again, welcome and congratulations to Tracy, my dear friend, Professor Tracy Robinson. Thank you.
Thank you very much, Dean Ali. Now, Professor Robinson's career at the university began at the Cave Hill campus in Barbados, where she spent some 15 years before transferring to Mona Law. And so she has strong collegial ties with that campus, which I suppose can validly claim her too. So in recognition of Professor Robinson's long association with our sister campus and the strong professional connections she developed while there, we have asked Dr. Halima Deschong, who has up to recently been the head of the Institute for Gender and Development Studies, Nita Barrow Unit at Cave Hill, to offer cross-campus greetings. Dr. Deschong.
Thank you very much, Dr. Blake. Thank you, Chair. Can you hear me? Okay. Distinguished judges and guests, Dr. Tomlin, Deputy Principal of the University of the West Indies Mona campus, colleagues and students of the UWI, members of the media, and everyone joining us in person and online, good evening. And thank you, of course, for the opportunity to celebrate the singular contribution of Professor Tracy Robinson to the Caribbean intellectual tradition, specifically in relation to law and legal theory, questions of citizenship, and feminist praxis, theorizing, activism, and mentorship. I will admit that I feel a heavy weight of responsibility in my attempt to reflect on just how profound Tracy's scholarship and organizing have been in shifting knowledge and strategies for ending complex gendered harms in our region. And even as her focus on the felt effects of inequality remains an enduring feature of her work, equally present is a clarity around how, in this region, we make life in spite of, beyond, and away from these systemic harms. Hers has always been and remains an urgent and uncompromising voice. Dr. Tanya Haynes, my colleague at the Nita Barrow Unit at Cave Hill, describes Professor Robinson as, and I quote, one of the region's most sustained and critical feminist voices and finest legal minds. Unlike too many other Caribbean scholars, she views the law as a site for the examination and production of Caribbeanness. Her analysis demonstrates how the law simultaneously produces and erases gendered power relations and how this is linked to sex and gendered bodies, end of quote. Now I reference this significant strand, and I call it a strand because Professor Robinson's work is quite expansive. This particular strand of her work I highlight to shine a light on the impact she has had on so many of us as students of Caribbean feminism, as feminist thinkers and doers, as well as the impact of this work on the dreamers among us. Tracy, when I mentioned to the regional IGDS team, many of whom are present here tonight and online, that you will deliver the your inaugural professorial lecture, the celebration and praise were abundant. And I take this opportunity to congratulate you on behalf of our Cave Hill and IGDS family on your most deserved elevation to professorship. We owe you a huge debt of gratitude for your scholarship, which has shaped so many PhDs, masters, as well as our programming at the undergraduate level at the Cave Hill campus and across the entire UWI. Your work is threaded through our syllabi, scholarship, and organizing. Further, the outpouring of gratitude from colleagues at Cave Hill, where you spent the better part of your UE career, as we've heard tonight, has been tremendous. Citing her experience with you as a mentor, Dr. Haynes also remarked that, and I quote, Tracy has been very generous to me when I was a graduate student, intellectually and otherwise, agreeing to be interviewed for my research on Caribbean feminisms and shaping her own relationship with feminism with me. Sharing her own relationship with feminism with me. Her scholarship is unparalleled in terms of the work on gender and the law and on sexuality without in any way sort of rarefying the law. It is this commitment to breaking new ground, Tracy, and encouraging others to do the same that characterize your presence on the Cave Hill campus Faculty of Law. Professor Robinson remains a force at the Cave Hill campus, even as she was institutionally located in the Faculty of Law. Her research and impact across the wider campus and beyond are still felt. We celebrate interdisciplinarity in the IGDS. For us, it is not simply that your writing and citational practice transgress disciplines, but that you work in ways that expose disciplinary fictions. And at Cave Hill, we are all aware that you're a Jamaican, Tracy, but it was never in our imagination that you would depart from Barbados and return home. That said, you continue to shape minds across the region, from your creation and delivery of the third-level undergraduate course, which is now taught here, Gender and the Law, to opening so many doors for us as graduate students and academics. And I want to end with a tribute to you from Dr. Latoya Lazarus, who is a research fellow at the Sir Arthur Lewis Institute for Social and Economic Studies, SALISIS, at Cave Hill. She remarked, and I quote, "Tracy has been tremendously supportive of my career. When I came to Cave Hill that year from York, I didn't have much experience working with Caribbean scholars, and I was doing research that was focusing on the Caribbean. And that one year where Tracy sat me down, she gave me her time. I remember in between me auditing some of her classes, she decided, let's do a reading course. So we would have coffee in her office and discuss readings and where my research was going. And by the time I left Cave Hill, Tracy had given me enough confidence to break away from a kind of mundane project I was seeking to do. And she allowed me to claim voice. And it is in fact Tracy who encouraged me to pursue the study of Caribbean religion and its impact on gender and sexuality. And so I am always grateful to Tracy for that. In fact, one of my first publications came out of those interactions with Tracy. And so, from the beginning of my academic career, she has always been supportive, always willing to chat and discuss my research, willing to share ideas with me in how to make the projects better or how to advance my scholarship. And so I think very highly of Tracy, not just as a lecturer, but as a mentor, as somebody who is passionate about the work she does, and passionate about guiding other scholars or potential scholars into finding their own niche or form of contribution, into finding their own voice in the way they can contribute to social justice work in the Caribbean, end of quote. I was introduced to Professor Robinson's work while conducting, and this is me now, sociological research on men and gendered violence. Once you discover her work, it is difficult to see the world the same. I can't think of a single academic paper, Tracy, that I have published where you're not cited. And like Latoya and Tanya, I too have been the beneficiary of doors that you kept open for us to enter, pathways that represented important turning points in our lives. So our hearts are full. You see, whether it is in the work you do with Europe, or your service to the Inter-American Commission on Human Rights, or to your unmatched commitment as a facilitator of learning with our students, Professor Robinson, in her own words, insists that, and I quote, "The lives we imagine must include our own, so that our destiny, desires, and communities are alive with the large images we debate and help construct," end of quote. Professor Robinson, on behalf of your Cave Hill colleagues and our IGDS regional team, I reiterate our love and gratitude for how you have taken up space in our lives as mentors, as family, and as friend. Again, congratulations on your elevation to professorship. We thank you, we love you. Peace and blessings.
Thank you very much, Dr. Deschamps. And now we move to the introduction of our inauguree, which will be done virtually. It is the tradition in inaugural professorial lectures at the UWI that the inauguree be introduced not only by people who are intimate with her research and work, but by people who themselves are connected with this academy. Introducing our inauguree are Ms. Roberta Clark, President of the Inter-American Commission on Human Rights, who has lectured and conducted research at both the Cave Hill and the St. Augustine campuses, and Dr. Arif Balkan, a judge of appeal in Belize, who has been a lecturer in the Faculty of Law at both the Cave Hill and St. Augustine campuses, and who also acted as law dean at St. Augustine. Unfortunately, given their engagements, neither Ms. Clark nor Dr. Balkan could travel to Jamaica, but they have recorded their introduction of Professor Robinson. And so may I ask that the recorded introduction of our inauguree be played.
One of the delights of work of the mind and the heart is meeting up with people who share causes, but who come with different personalities and perspectives, different ways of approaching the subject matter, and other ways of interacting with the world. I do not recall when I first met Professor Robinson, but I was in my late 30s, and she is a generation younger than I am. And so I have been able to follow, sometimes closely, sometimes at more distance, the trajectory of her work, of her contributions to the Faculty of Law through her teaching and research, and to the Caribbean community through her advocacy and engagement with policy development. She has worked at UE consistently with short stints at other universities. This singular focus tells us something about her sense of who she is, of where she belongs, and of her sense of obligation to give back and to pay forward to this Caribbean. Both Professor Robinson's parents were in public service. Her mother a teacher, her father a lawyer. She is a teacher of law. It is evident across the themes that she teaches, writes, and advocates that Professor Robinson visions a fairer, more just, less disadvantaged, and kinder Caribbean. She carries the history of the region in her deep consciousness, and she calls on us all to honor the resistance of the dispossessed and the discriminated, and to fight for equality and freedom. In the 1990s, Professor Robinson was the first and only feminist legal scholar at the University of the West Indies. Others had written about women and the law, but they did so in more descriptive ways. She asked new questions, eschewed easy answers, provided jurisprudential insights, and remained engaged in collective and interdisciplinary thinking, and she did that generously. The titles of her work tell us some of the story of her intellectual rigor, but also of the poetic way she has of putting together that work. So, for example, one title, Fictions of Citizenship, Bodies Without Sex. Professor Robinson is not one for writing long paragraphs about what the law is or what it says. That is important, no doubt, but she's a theoretician, articulating conceptual frameworks through which we can better understand the relationship between law and social and political structures, both in public and, yes, private spaces of the family, but also how what happens in private spaces where gender relations are reproduced, social relations are reproduced, affects and is affected by the definition and exercise of power in the public space. Professor Robinson's feminist scholarship has drawn on critical legal theory tradition, the central tenet of which is that the substantive and procedural content of law most often reflects and reinforces power structures. Simply, in her scholarship, she illuminates for us the politics of the law. So, for example, in the first post-independence constitutional development processes, she offered the insights that these were premised on the assumption that men were the archetypal citizen and women their subordinates. And in the second constitutional reform processes that she analyzed, she argued that the masculinist character of past constitution making has tended to be neither, in her words, problematized nor entirely abandoned in the current exercises of reform, as evidenced, she said, by the inattentiveness to gender balance in the composition of the apparatuses of reform. Law is often made in the interest of those involved, those authorized to make law, which is why her work is a suggestion, a strong suggestion, for a broader participation of citizens in lawmaking.
While we acknowledge Tracy's uniquely interdisciplinary approach to research, so different from traditional approaches to Caribbean legal scholarship, which emphasizes Black letter analysis, her contribution to the latter has nonetheless been formidable. A prolific output across the areas of family law, human rights, constitutional law, and governance is matched by the depth and profundity of her insights and analyses. Fundamentals of Caribbean constitutional law, of which she is the lead author, has been described as a masterwork, embraced by legal scholars across multiple disciplines. It has become an indispensable tool for practitioners. Already, less than a decade after its first publication, it has been cited in more than 36 cases at the appellate level across the region, including by the CCJ and the Privy Council. For an indication of the book's influence, its analyses have figured in some of the most consequential cases of our time, shaping discussions on the constitutionality of contested COVID-19 delegated legislation, the mandatory nature of the death penalty in Barbados, the colonial sedition law in Trinidad and Tobago, and constitutional interpretation in the assessment of Jamaica's anti-money laundering regime. Considered along with her entire body of work, it would be no exaggeration to say that in her areas of research and publication, Professor Robinson is a towering intellectual, a figure of commanding authority in the region.
And so I was, and I was not the only one, drawn to her work like a moth to the flame. And on the flame characterization, there are few people who can mesmerize a room like Tracy when she's given a talk on something that matters deeply to her. If I have to think of a theme that brings all of her work together, it is that she expects of herself that her intellectual life contributes to social justice. She uses all the tools, research, teaching, outreach, to drive that change. She's engaged in praxis. So, for example, Professor Robinson's exhaustive review of domestic violence legislation in the Caribbean was both an acknowledgement of the work of the women's movement, as it was a call to action to Caribbean states to engage in gender and social analysis to understand better how those laws advanced or ignored access to justice issues. It was an enormously practical guide for those of us working on domestic violence law reform, and Professor Robinson, it needs updating. Another example of her contributing to change, back in 2013, Professor Robinson was challenging gender binaries in a way I think is now better understood and more widely accepted. Speaking to the Caribbean Association of Judicial Officers, CAJU, at their third biennial conference on the theme of equality, justice, and Caribbean realities, Professor Robinson reminded the room of judges. The notions of gender capture not just expectations that we must be male or female, it prescribes a clear binary. Persons, she said, who fall short of this can find themselves demeaned, punished because of gender norms, sexual orientation, and gender identity. I have no doubt that this discourse with judges back in 2013 contributed to the CCJ jurisprudence which came out of McEwen, the case from Guyana, where the CCJ declared that the law which prohibited cross-dressing was unconstitutional. Apologies. That judgment begins with the verity. Difference is as natural as breathing. Infinite varieties exist of everything under the sun. Her work with others through URAP was seminal in what now looks like a judicial revolution in at least 6 countries where same-sex criminalization has been declared to be a violation of human rights and as unconstitutional. Her work on sexual harassment has also shaped law reform in the region.
There are other markers of Professor Robinson's intellectual heft, such as in the regional and international recognition which she commands. The range and prestige of her influence are impressive, demonstrated in the positions of leadership she has occupied. A very short list would include the numerous regional commissions on which she has sat, dealing with diverse matters, such as judicial appointments and family law, as well as positions to which she has been appointed in international bodies, such as the Independent Fact-Finding Mission in Libya, which was established by the UN Human Rights Council in 2020, the Board of International Planned Parenthood Foundation, the Lancet Commission on Gender-Based Violence, and the PAHO WHO Independent Review of Equity and Health Inequalities in the Americas. Professor Robinson, again, uniquely among her peers in the law faculties across the region, among which I count myself, has the distinction of being regularly and consistently invited to teach at some of the most prestigious universities in North America and the UK, such as UPenn Carey Law School, NYU Law School, and the University of Toronto Law School, to name just a few. These are often repeat invitations, no doubt due to the popularity of her courses. That Tracy chooses to stay at UWI, eschewing a more lucrative career at one of these prestigious global institutions, is yet another testament to her commitment and love for the region. On a personal note, I met Tracy relatively late, after I joined the Faculty of Law at Cave Hill in 2008. And to adopt Roberta's word, I too was mesmerized by her intellect, of course, and her engaging style of teaching, which I observed up close as we co-taught in my first 2 years at Cave Hill. But my friendship with her developed rapidly, not merely because of this magnetism, but more because of her incredible generosity and warmth. Human rights is one of Tracy's chosen areas of specialization, but for her, it is much more than a mere academic pursuit. Respect for human rights is integral to Tracy's makeup, something that she lives and practices in her everyday life. Deeply solicitous of her students, unswervingly ethical in all her dealings, and generous to a fault with others, Tracy lives and practices what she teaches. For all of these qualities, the professional and the personal, Professor Robinson is a regional treasure. The recognition UE has now conferred on Tracy has long been obvious to many, as I said, to top-ranked universities, to the UN, to the OAS, to her peers in academia, to regional judiciaries, and most especially to her students. We could fairly say, to borrow an expression, that this professorship is merely declaratory, not constitutive.
Ladies and gentlemen, I give you Professor Tracy Robinson. Please welcome her.
President of the CCJ and judges online, the Honorable Mrs. Justice Marva MacDonald Bishop, the President of the Jamaican Court of Appeal, and it gives me enormous pride to introduce you as President. We are 3 of your former classmates teaching at the Mona Law. I join in offering you the biggest congratulations, President, on behalf of all of us at the University of the West Indies. Some here may not know that you not only excelled in the Faculty of Law at Cave Hill, but you also excelled in the Faculty of what is now Humanities and Education. We own you, and we're honored today by your presence. Thank you so much. The Honorable, thank you, Marvel. I am keeping track of my time. The Honorable Mr. Justice Seymour Panton, Chair of the Integrity Commission and former President of the Court of Appeal. I'm not sure if commiserations are in order. Justice Panton. Online, the Honorable Mrs. Justice Zayla McCalla, former Chief Justice of Jamaica. The Honorable Mr. Justice Patrick Brooks, online, former President of the Court of Appeal. With us, the Honorable Justice Hilary Phillips, distinguished former Judge of the Court of Appeal. The Chief Justice of the Bahamas, online, the Honorable Mr. Justice Ian Winder. The Chancellor of Guyana, online, the Honorable Justice Yonette Cummins. Chief Justice of Guyana, the Honorable Justice Roxanne George. Sitting judges all, several are with us today. The Solicitor General, Marlene Aldred. Deputy Principal, Dean Zally Ricketts Taylor, and Thame Online, the Executive Director of the Mona School of Business, and of course, the IGDS Director. So Halima is now the new Director, University Director of the IGDS. The Principal of the Norman Manley Law School and Eugene DePuch Law Schools online, and my dear friend, Senior Tutor Greenaway of the Norman Manley Law School. The many lawyers in the room. These include the esteemed Caribbean law giants, the Honorable Dr. Lloyd Barnett, the Honorable Mr. Michael Hilton, the recent President of the Jamaican Bar Association, Emil Leiber, Peter Golson, the husband of Suzanne Golson, my colleagues in the Faculty of Law and at the University of the West Indies in the room, my classmates, my former and present students. You see some students on the side, my dad, my brothers, and their families, my beloved aunts and cousins. Not that my father and brothers aren't beloved. My aunts are also very special. My friends, it's good to see you. Thank you for being here in person. Thank you for being here virtually from different parts of the Caribbean. Thank you for joining us at the University of the West Indies as we sit in conversation with our peers, with students, and wider communities we've served for over 50 years. As you've heard, I worked at more than one campus of the University of the West Indies, and my most meaningful work with Arif and others has been with colleagues across the campuses and the faculties of law. I'm grateful for the very generous words, Halima, from you and colleagues, from the IGDS family. I also want to, as you begin your leadership as University Director of IGDS, to offer my congratulations in this new role, my support, of course, and our very strong confidence in your leadership. Roberta and Arif have been my closest collaborators in my life at the University of the West Indies, nearly 30 years, in empirical research, in strategic litigation, in human rights advocacy, and constitutional law scholarship. I have made my way with their exquisite care, their accompaniment, their tutelage, their friendship. I thank them most for that, and of course for their extravagant words of introduction, some of which have frankly left me speechless. I want to begin this evening with an undated and unpublished article of considerable importance on file at the Faculty of Law Library at the University of the West Indies by what was then a young and formidable new lecturer at the Faculty of Law, Yui from the Leeward Islands. She herself had been one of the earliest graduates of the regional legal education system, and she asserted, the fact is, West Indian law may be bad law, it may be irrelevant law, it may be unsuitable to the peculiar circumstances of the region, it may be imposed law, that is the law directed to the colonies by the British Parliament. It may be all that or even worse, but it is still West Indian law. And that is only the starting point. If you haven't guessed, you're hearing my voice and the words of the legendary senior tutor emerita of the Norman Manley Law School, the Montserratian Dorcas White. In the less well-remembered part of her life as a law lecturer at the UWI. I don't read that passage. I want to tell you that I hear it. John Callahan talks about how the eye calls the ear to attention, how words are in pursuit of voice. I hear Miss White's voice almost like a testimonial, a bearing of witness. The fact is, she tells us, hers is a response, a loud one, to those who said Caribbean law was simply imported and imposed English law. Miss White added, with the evocative metaphor of the river, she says, certainly English law is the acknowledged fontes juris, but this does not make the law in force in the West Indian territory English law. She said, if the water of a river traces its source to a mountain spring, it would not be improper to refer to the spring as the origin of the water. But to insist that the water is still spring water, she says, is to be guilty of directional confusion. Let me give you an example. In 1972, a decade after its independence, Trinidad and Tobago transplanted the then recent UK reforms to matrimonial causes and matrimonial property. The UK law was the spring water. The legal profession in Trinidad and Tobago understood from the outset that their transplantation of the UK law would, as one of its members, Lily Ferdinand, put it, have repercussions in sister Caribbean territories, and indeed it did. The UK Act was transplanted all over the Caribbean, where it can still be found. In a very early case filed in 1974, the High Court had to resolve a matrimonial property dispute between Mr. and Mrs. Jack. They had been married for 5 years, but they had been in a serious committed relationship, living together for 47 years. The statute asks the judge to have regard to the duration of the marriage, and the judge was invited by counsel to have regard only to the wife's contribution during those 5 years. Justice Bernard rejected that. He said he profoundly disagreed and used what Minda Lazarus Black calls his common sense knowledge to determine how to exercise his discretion. His arithmetic included counting the long period of cohabitation before marriage because, he says, to quote him, the concubinal association is an accepted part of life. This soon became West Indian law and the norm in other parts of the Caribbean with the same law. Clearly, we were in the Caribbean river water, even if it had many tributaries. Dorcas White was hardly the only one answering a set of arguments about the nature of law in the Caribbean and calling for a new decolonial dispensation, a response and call, if you like. I would say particularly in the 1970s and the 1980s, a generation of Caribbean students, some are in the room, lawyers, distinguished jurists and academics bore witness to varying conceptions of West Indian law as facts, as a projection of what we wanted. The late Sir Sridath Ramphal, in his 2011 inaugural Distinguished Jurist Lecture of the Judicial Education Institute of Trinidad and Tobago, said there is no worthier, perhaps no other, destiny to which we can aspire than a regional one. And law, he says, is one of our most reliable bonding agents. We do not have to contrive it, it bonds us now. My former dean, the late Professor Simeon McIntosh, spoke of a Caribbean hermeneutics of law. For him, this meant our own way of interpreting our constitutional and political work. The president of the CCJ, Justice Adrian Saunders, has called this Carib's prudence. Indeed, both his predecessors, President de la Bastide and President Byron, have spoken eloquently about the role of the CCJ in developing a Caribbean jurisprudence. In the same vein, my former colleague Leighton Jackson, in a publication David Berry and I co-edited, speaks of FIWI law, law for us, our law. Professor Seshona Wheatle and our own Mona's Dr. Unique Campbell most recently have engaged with the notion of the creolization of constitutional law in the Caribbean. But we're in a moment of uncertainty, and for many, a moment of palpable anxiety. The notion of West Indian law, a Caribbean jurisprudence, put as a normative project, what we ought to have, or descriptively, or as an explanatory project of what we indeed have, or a claim of inspired distinctiveness. That notion feels as if it is in flux. Invariably, this is where we note the recession. In 2001, 12 Caribbean states ratified the CCJ agreement. As the court approaches its 20th year of operation, only 5 have accepted its appellate jurisdiction. 4 of the remaining 7 have made unsuccessful attempts at constitutional change to introduce that jurisdiction. In her ethnography of the CCJ, Lika Battingun suggests that there are moments where the CCJ hails us to constitute us as a Caribbean public and, to use a Jamaican expression, win a response. She calls this interpellative misfires and dissonance. This year, Prime Minister Andrew Holness indicated that his government was not averse to ending appeals to the Privy Council from Jamaica, but signaled that he thought Jamaica should be creating a Jamaican apex court to replace it rather than join the appellate jurisdiction of the CCJ. Nearby, we've forgotten that the Bahamas, the 5th nation in the Anglo-Caribbean, is not a party to the 2001 CARICOM agreement to establish the CCJ. Moreover, in 2006, the Bahamas became the first jurisdiction to invite the Privy Council to sit in its capital. Between 2006 and 2017, the Privy Council made 4 visits to the Bahamas. In the multi-ethnic and plural Trinidad and Tobago, there's a worry that we're in a region where Caribbeanness is closely associated with blackness, a concern that a Caribbean jurisprudence will essentially be essentialist, refine Afro-Caribbean identity, excluding inter-Caribbean subjectivities, religious diversity, and lives. My modest project today is to make 3 arguments about the future of law on the regional plane. They may not fully settle our nerves, but my intention is to more plainly urge what Iris Murdoch calls a moral discipline of the mind. A look again, giving careful and just attention to a Caribbean common law as a form of reflection and response to a shifting and changing environment. I think it's helpful to hold the river in our attention. That effort of attention may condition how we imagine Caribbean law. Tributaries flow into the river, Caribbean law, or a tangle of tributaries constitute the river in some places. Some streams are nearby and never join the river. Some divert from it. But even when they change course and size, we see the land the river planed, the communities it connected and enlivened by it. My first claim is a preliminary one, a point in limine, if you wish, that if we hold Caribbean law in our attention, like the river, we're likely to see that it's entangled and fuzzy and plural. Whether we perceive this and acknowledge its existence, Caribbean law that is, depends a lot on how we see law in the first place. My second suggestion this evening is that we give careful and just attention to what that community of lawyers, students, and judges bore witness to in the 1970s and 80s, a neglected history. This is where I locate Ms. White's intervention. And at the risk of being melodramatic, I think the Anglo-Caribbean had a moment in those decades. We memorialize, we monumentalize, we honor and we name things after many of the voices of this period. I think it's time to shift our attention away from their tumification and to take time to listen and engage, to hear what they had to say to each other and intergenerationally to us. I think of the more important things we might take away from this foundational moment is the value of what I'm going to call minding the middle as a critical space of development of Caribbean law. Our apex courts matter terribly, but they're only part of a discussion about a Caribbean common law. My third suggestion comes back to now, the present, where I think we are pop style. And to borrow Rahul Rao's book title, We Are Living Out of Time, I have friends here who will not take kindly to a negative association with popping style. When Norman Manley and other parliamentarians in 1962 insisted that a prohibition of slavery in the Jamaica Constitution was, quote, not appropriate to a country with Jamaica's civilization, respectfully, as someone who admires Norman Manley, and as this was popping style. I think we're popping style as what I'm going to call post or past it people. Those who in their sophistication say we have moved beyond post-slavery, post-colonial, post-independence. I think of the common law, a Caribbean common law, as a heuristic, a GPS if you wish, that shows us where we are. It tells us we're living in what I am going to call today the longue durée and transatlantic intimacies of decolonization at a time when we've been told that empire is long dead. But first to the point in limiting, that perceiving Caribbean law as fuzzy may be essential to seeing how it is already and indispensably part of our lives. Fuzziness is generally thought of in negative terms, as obscurity, the shadowy, the unfocused. I want to offer an image of fuzziness as a description of law that's less fraught, textured, nuanced, plural, and diverse, put together in different ways at different moments, hence the resonant images of, for me at least, afros in my family, my mother, my father, my niece. Drawing attention to the fuzziness is one of the ways of acknowledging and responding to what I think are two important skeptical concerns about law on the regional plane. The first concern is, well, law is national, isn't it? It feels as if in our everyday life, the law we meet is markedly national and not regional. The second argument is related to the first. It is that the desire for national self-determination and anti-colonial institutional building does not inexorably lead to regional rather than national law or legal institutions. Well, let me come to the first concern. Yes, law is often national, but in many instances, national law is entangled with post-national and regional law. The Jamaica Domestic Violence Domestic Violence Act, 1995, which I have been teaching in the last few weeks, is still, after the reforms in 2023, essentially a version of a 1990s CARICOM model, with 2004 reforms that closely followed those made 5 years earlier in Trinidad and Tobago. Nico Krish makes a point that law is typically thought of in the singular, but in most places, most of the time, law is lived in the plural. He adds, law is both one and many things at the same time. It's fuzzy. The second claim, that national self-determination doesn't necessarily lead to regional institutions, is in principle correct. But that hardly defeats the normative case for law on the regional plane, or the descriptive one that we already have it. It simply acknowledges that there are alternatives. The alternatives prompt us to reflect on why Anglo-Caribbean states have on so many occasions made a sentient choice to orient their national lawmaking, that which is often seen as national self-determination and sovereignty, towards regional developments. One of the important reasons why we do this is because we save costs. We generate good quality rules by working together in the creation of laws. This is Kevin Davis's point, who highlights the high cost in small jurisdictions of making laws that fit our societies. Jamaica's effort to introduce more fit-for-purpose family property legislation took nearly 3 decades and produced a regime, the Property Rights of Spouses Act 2004, that was both long in coming and far from perfect. Key to understanding a Caribbean common law is also that law is not just national, post-national, and entangled, but it has important institutional dimensions. I'm drawing here from the work of University of Melbourne's Liz Hicks, who analyzes the legal profession and legal professional culture as critical dimensions of law's institutionality. If we are honest, although we know that our parliaments make law for the peace, order, and good government of the polity, lawmaking is not often what we associate our parliaments with. I dare you to ask 10 persons what members of parliament do. My guess is that one, and that would be a lot, would say that parliamentarians are lawmakers. I actually know the answer because I asked my students this question indirectly last week. Richard Neely cynically attributes legislative inertia to the fact that, as he puts it, the legislature is an organization designed to do nothing. It is more focused on preventing the enactment of bad laws than passing good ones. The result is that, quite apart from whether we have ourselves made laws in common, we have retained and received laws that are common. Fertile ground for the development of what I called a Caribbean common law in a short article in a special volume of Race and Class, edited years ago by Aaron Kamugisha and Alyssa Trotz. Common law is the paradigmatic fuzzy legal concept, one closely linked to legal professionals and particularly to judges. Common law can mean unwritten, judge-made law. It can mean all judicial decisions or case law, including cases interpreting and applying what for us is often quite similar legislation. Common law can mean a legal system shared by states and territories, colonized by Britain. It can mean customary law. It can represent the identity and institutions, who we are, what Norman Manley called the loyalty of common sense. Importantly here, a Caribbean common law in an institutional sense has not been undone by legislative inertia. In some cases, it has thrived common transnational courts that make binding precedents across several Caribbean jurisdictions where the law and issues are the same, have been a powerful catalyst for Caribbean common law. For this reason, a Caribbean common law has been colonial, it has been anti-colonial, and will see decolonial. Nevertheless, it is hard not to notice the legislative inertia in respect of the CCJ's appellate jurisdiction in CARICOM's two largest jurisdictions. Still, if we look again, if we give careful and just attention to the legal profession as an institution of law, we actually see a robustly regional and transnational institution in its judges, in the members of its service commission, in its staff, in who appears before it. Some of Jamaica's most well-respected lawyers and judges have been members of this regional service commission, the most powerful judicial appointment body in the Caribbean. They include Chief Justice Brian Sykes, Justice Hilary Phillips, who is here, senior counsels Jacqueline Samuels-Brown, Tenanya Small, the Honorable Mike Hilton, the Honorable Dr. Lloyd Barnett, and the late Justice Dennis Morrison. Indeed, Dennis Morrison was not only the president of the Jamaican Court of Appeal, he sat on appellate courts in Belize, the Cayman Islands, and the Turks and Caicos Islands, as have other eminent Jamaican lawyers and judges, several of whom are in the room today. Also in this room are Jamaican judges who have worked as lawyers in other nearby Caribbean jurisdictions. I see Justice Kisok Leng. At CARICOM in Guyana, I see Justice Fraser. And nearby, I note that current and past Chief Justices of the Cayman Islands, the last one and the current, are Caribbean-trained and Jamaican nationals. Jamaica cannot be estranged from law on the regional plane when Jamaicans are so integral to regional institutions. Much is understandably made of the CCJ being headquartered in Trinidad and Tobago, which has not accepted the court's appellate jurisdiction. This country may be outside the CCJ's appellate jurisdiction, but its lawyers are firmly within it. In the summer of 2020, the CCJ heard a Guyanese case which effectively ended the 5-month dispute about declaring the results of that tumultuous elections. Undoubtedly one of the most important decisions of the CCJ. It was applying Guyanese law. Well, look at the list of lead counsels. The Uber Trinidad and Tobago lawyer, Douglas Mendez, called to the bar in 10 of 12 Anglo-Caribbean states. Former Attorney General of Trinidad and Tobago and St. Augustine lecturer, John Jeremy. Now current Attorney General of Trinidad and Tobago, Reginald R. Moore, and former chair of the Council of Legal Education. The very highly regarded public law senior Trinidad and Tobago lawyer, Fayed Hussain, and the former Attorney General of Antigua and Barbuda, who hails from Dominica, was one of the first graduates of the UA Law program, Justin Simon. The river course never stays the same, but if we look at our institution and how law moves, we see fuzzy Caribbean law, perhaps fuzzy lawyers all over the place. I simply want to note that if a Caribbean common law is fuzzy, it has a sharp edge too, which is an Anglo-legal professional exclusivity. We have been slow to think through a Caribbean common law that acknowledges our relatedness in ways that are not lawyer-centered or anglicized. We often ignore the more organic sense of relatedness through law that Professor Simeon McIntosh talked about. It is this relatedness that I heard Suniti Maharaj of the Lloyd Best Institute articulate in a town hall meeting in Port of Spain in June of 2018, a few hours after the CCJ had completed its hearing in the McEwen case, which Roberta mentioned, a case which several of us were involved in. In talking about the 1893 post-slavery vagrancy law, which was ultimately invalidated by the CCJ, and I see Ronzoni Rainford, who was there. It made it an offense for a male to be dressed in female attire for an improper purpose. Suniti Maharaj pointed out that to one degree or another, the mass of people in the Caribbean have been living lives of improper purpose. I think there's much to be gained from recognizing this sense of relatedness, pursuing conversations about how Caribbean law responds to, or as some have described it, unfinished project of freedom. My second thoughts about the future of a Caribbean common law asks us to hold in close attention developments in the 1970s and 1980s, contributions described by scholars such as PBC Professor Rosemary Antoine in her book on Caribbean legal systems. I temporalize this period as having a moment. And I see many students, persons who were members of the very first class of 1970 entering the Faculty of Law. Do you mind if you just raise your hand? 1, 2, 3. Still you too, Mr. Saunders. Hear the voice of your first dean, Professor Keith Paget, who worked at University of Sheffield with Sir Roy Marshall and on the Law in the West Indies project in the 1960s.
Identifying. Focus 1972, Program 25, first part of interview with Dean Paget, Law Faculty, Barbados, for broadcast on JBC, Sunday, July 30, 9 o'clock p.m. Program beginning 10 seconds from now. Focus! A university extramural department radio series which draws attention to developments in our Caribbean society. In this program, we present the first part of an interview with Mr. Keith Paget, who is Dean of the University of the West Indies Law Faculty with headquarters at the Cave Hill campus, Barbados. Mr. Paget speaks about the Law Faculty and its policy of operation, its differences from other law schools, and its role in preparing law graduates for the Commonwealth Caribbean. Hugh Morrison of the University Extramural Department interviews Dean Paget. Before talking to you, I was talking to 1 or 2 members of your faculty, and it came as a bit of a surprise to me that Caribbean law is not, strictly speaking, British law.
I don't really know why it surprises you, because these territories have had legal systems with a degree of independence for quite a while, where obviously the laws had to be adapted to meet local needs, and where the smallness of the community sometimes demands different types of organisation and institutions. Basically, I think it's true that most of the systems are derivative in that they can trace their origins from England. But there are variations. For example, in St. Lucia, there's still a fair amount of law which derives from the civil law system, the French system. And in Guyana, there is still, in some very important areas of law, the Roman Dutch principles obtaining. But even within the derived English law, there are important variations which students have to recognize.
Yeah. Of course, we aren't colonies anymore, most of us, or many of us, but we still tend to be years behind.
I think it's true that we are, in this area, not as up-to-date as may be, but the question implies that we ought to be producing the same kinds of solutions to problems as are to be found in, for example, England. And this is where I part company. I think it's very important that the region recognizes that it has its own individual needs and that it must begin to devise its own individual legal solutions. And the profession itself must be demanding this, and the courts must reflect this, and the legislation must, in fact, bring it about.
Indulge me for a moment in hearing more voices from that period and their pursuit of voice. On November 1, 1976, Jamaica became the first country in the Caribbean to enact what was the region's most important early anti-discrimination legislation, Status of Children legislation. Rex Nettleford famously called this a stigmatization initiative. What we generally don't know is that years before 1976, the first undergrad students at the University of the West Indies Faculty of Law, established in 1970, wrote their undergraduate research law and society papers on family law and this very issue, making the case for reform. Notice that many of these studies, if we move to the next slide, come from Jamaican students. The 3 from the class of 1973s, their papers are in these lists. It includes a Guyanese student, a Bahamian student, a Belizean student, a Trinbagonian student, all writing on the status of children born outside marriage and the doctrine of nullius filius. All these studies preceded the passage of status of children legislation by years, and in the case of the Bahamas, by decades. Norma Ford, one of the papers mentioned here, her foundational work as an LLB student on marriage in Barbados supported her later participation in the reform processes that led a decade later to the passage of the historic Barbados Family Law Act. Generations of regional students taught by her, some of you are in this room, learned about the Barbados prototype as they went home to their own countries. Dr. Eileen Boxhill's LLB thesis on family law and family structure led to one of the earliest PhDs from graduates of the UA program. As a member of the Family Law Committee and later Director of Legal Reform, she contributed to a series of key family law reforms in Jamaica. Listen to one of the first lecturers at Mona, a man named Charles Taylor, talk about the students he met, some of whom are in the room 50 years ago. And by the way, Dr. Lloyd Barnett was one of the early tutors in the Faculty of Law. Let's hear from, Charles James.
University on the Air. In this program, we present an interview with Mr. Charles James, one of the first lecturers in law when the University of the West Indies began its law faculty. Mr. Charles James has returned to Britain, where he is now a lecturer at the University College, Cardiff, Wales. In this interview, he speaks first about the law faculty at the University of the West Indies, then about the practice of law in the Commonwealth Caribbean.
Now, I should imagine that in a field like law, where the use of language is terribly important, that you encourage a lot of talk and discussion in your various courses.
This also is a crucial part of teaching law, as I found it personally here in Mona. The Jamaican student in particular is very eager to discuss and to dispute principles and policies. And of course, legal education is no longer a process whereby one stands in front of a class and delivers a set of rules, expecting the class to imbibe these and repeat them in the appropriate form at examination time. Legal studies these days are becoming increasingly more normative, and one expects the value judgments of students to be arrived at through a process of discussion during class time. And in this way, we can achieve a considerable amount of progress within teaching and learning the law by using the very old Socratic method of continuous discussion and debate during class periods instead of the old-fashioned pontificatory lecture. The students now, we find at Mona, and I'm sure at the other campuses, much more readily take part in the discussion, participate in the learning process.
The value judgments, the sharp normative lens produced what I'm calling a Caribbean common law, nationally focused and regionally and institutionally inspired. These students and teachers in the early 70s would have known that the independence constitutions, the associated state constitutions, barely mentioned the word equality as a constitutional precept. They gave very circumscribed protection against discrimination, yet they very decidedly urged a shift in our legal mores that I think amounts to a very modest version of what Yale Law School's Bruce Ackerman calls a constitutional moment. He describes constitutional moments as ones of extra-legal higher lawmaking that produce constitutional change outside the amendment process. The sense of the Constitution I am invoking here is similar to that of Simeon McIntosh's, who describes the Constitution as an act of collective self-definition that addresses the values that would support a certain conception of the good life and justice and provide an elaboration of the institutions by means of which this life is to be achieved. In the 2 decades, not through constitutional reform, but ordinary lawmaking, judicial interpretation, public and scholarly commentary, I think we had something akin to a constitutional movement, characterized by audacious voices full of backchat. Audacious was Sir Hugh Woodin, who became the first Trinbagonian Chief Justice at independence and the first Caribbean Chancellor of this university in 1971. In 1973, his good friend, Aubrey Fraser, who was then the Director of Legal Education and at the Norman Manley Law School, wrote him excitedly to tell him about his new work and ideas on a conference presentation titled Law and the Illegitimate Child. Sir Hugh thanked him for the paper. He said it made for interesting reading, and then he sharply rebuked his good friend. He told him he had a quarrel with the use of the I word for children born out of marriage. I get furious, he says, when children are described as legitimate or illegitimate. I think a concerted effort should be made to see that the terms fall into disuse. I know they are common usage, but as the Director of Legal Education, this is a big rebuke. Please set an example for their discontinuous. In an excellent 250-page 2013 report of the Bahamas Constitution Commission, I see the I word mentioned just once. And just to say the concept was generally abolished by the then decade-old Status of Children legislation in the Bahamas. In the groundbreaking constitutional law case of Roll, which determined that a child born outside marriage to a Bahamian man in the Bahamas was constitutionally entitled to citizenship. Chief Justice Winder, in his ruling, which was upheld on appeal up to the Privy Council, made a handful of references to the I word, but as a legal artifact, mostly citing the older case, Fisher, that used the terminology. Yet in 2023, last year, the I word litters the judgment of the Privy Council's ultimate ruling on this case. In one paragraph, paragraph 38, and we could move to the next slide, Lord Lloyd Jones makes reference to I people, I children, the I child 6 times as facts in the present tense, batting around the word like he received an over of full tosses. Exhibit 1, the long durée of decolonization, where we loiter, we lime, we are making sport. In the same early 1970s, audacious were Guyanese judges, Justice Kenneth George and Justice Keith Messiah, long before their elevation to the highest ranks in the judiciary, who heard claims from Indo-Guyanese women in unregistered Muslim marriages, who used the law of trust as a means to recognize the relationship and the gendered care over decades given by those middle-aged women who had been cast out. Justice Messiah said that regard to the relationship was, to quote him, consonant with not only reason and palpable justice, but with the culture and the way of life of so many of our citizens. Audacious was Dr. Lloyd Barnett in 1974 to dare to challenge the constitutionality of the Gun Court Act, when the Privy Council to that date had never held a law to be unconstitutional in the Caribbean, far less in respect of a non-Bill of Rights claim, the very sort of claim that Professor Ralph Carnegie posited we should not expect to succeed. Bold was Dame Bernice Lake, who sharply criticized the Privy Council's approach to limitations on rights in the 1975 Antigua Times case. She complained that our jurisprudence, and she was thinking of the approach of Chief Justice Cecil Lewis, she said it was rejected. Not only rejected, but infected by the Privy Council in Antigua Times. With the inept application and or President of the Court of Appeal may relate to her analysis. The inept application of the rigors of the presumption of constitutionality, which she said so readily presents itself in the benign environment of the supremacy of Parliament. The audacity of Francis Alexis in 1976, just a year after completing 5 years of his legal education, to publish in the well-respected journal Public Law an article on one of the most existential questions in Caribbean constitutional law: when is an existing law saved? It was 4 decades before the seeds he planted bore and were fashioned into a distinctly new approach to savings law clauses by the CCJ in a death penalty case from Barbados, Nervée. This wasn't a romantic period. There were disagreements and criticisms. Still, it was the beginnings of giving voice to a conception of the good life that rejected our legal abjection, introduced concepts of equality grounded in human dignity, sought to redress our legal degradation, and called for responses to our disadvantage. We often forget that those who dominated this moment negotiated complex questions of law and morality, and whether our humanity and our dignity would be seen by the law, even if we were deemed to be living in sin, or born in sin, or married under bamboo. It was the beginnings, and think here of Dr. Barnett and Dame Bernice, of a conception of justice that strongly emphasized the value of limited government and the importance of judicial review of laws as a critical form of political accountability of government to the people, insisting that Parliament could not be sovereign here. We're in a profound moment of reflection on the very question of what Parliament can do now in Jamaica. So many of the developments of this period were made in the middle, audacious contributions by persons who were far from the heights of their careers. Some students, some new, very green lawyers. I remember hearing the Right Honorable Dr. Kenny Anthony point out more than once that several of the most important cases of this period, Thornhill and the Attorney General he often cited, were made in the middle and not at the top. He said, if you want to understand the significance of Thornhill, look not to the Privy Council decision, but look to the excellent judgment of Justice Telford Georges, the Dominican Uber judge in the High Court, much the same way Dame Bernice drew attention to Chief Justice Lewis's decision in Antigua Times. I think we must mind the dynamic middle as a dense but not unnavigable space of dialogue and exchange. This is, to my mind, the future of a Caribbean common law. It's the place where we ask to come back to the imagery of the river. So how you come over? Do you know that folk song? How you come over? Mr. Selector, can you give us 2 stanzas? This is Louise Bennett singing.
Why, oh, why, oh, why, oh, then how you come over? Aye, the river bank come down, the river bank come down, the river bank come down. Me couldn't come over. Why, oh, why, oh, why, oh, then how you come over? Aye, me tapping for walking, me tapping for walking. Me afraid me go drowned, it me never come over. Why, oh, why, oh. Why, oh, then how you come over? Me take piece of bamboo, me take piece of bamboo, me take piece of bamboo, me throw fire.
Says the Moortown Maroon, the community my grandfather hails from, to the Saramaka Maroon in Suriname. So tell me how you come over. Says the Jamaican family law students to their Barbadian classmate. So tell me, which way you come over? Says the Caribbean lawyers, which included many Jamaicans, A.J. Nicholson, Jackie Samuels Brown, Ian Ramsey, Earl Whittock, Glenn Cruikshank, Jack Harrison, Howard Hamilton, who went to represent persons charged with the murder of Maurice Bishop and others after the end of the Grenada Revolution to a wounded country that still needed due process. We are sorry, but we need to come over. Let me be clear, there is no promised land on the other side of the river. Law does not offer salvation. Still, a Caribbean common law is about lessons from those crossings, what Jackie Alexander calls pedagogies of crossings. Crossings, Faith Smith reminds us, are also crossroads and spaces of crosses. I have one last suggestion to make about the future of law on the regional plane, its value as a heuristic that aids our understanding of where we are, of what I call the long durée of decolonization, and I'll try to be brief. In the same 2011 speech by Sir Sridhar Ramphal, he was reflecting on the establishment of the new UK Supreme Court, and he said, are we in the Caribbean going to stop loitering at the doorstep of colonialism? Or are we waiting for an eviction? He was speaking in the wake of famous remarks of Lord Phillips, who became the first president of the court and was very ready for Caribbean states to go, in a remarkable turn, prompted by a series of excellent reasonings organized by Dr. Chris Malcolm and the law school's classes of 1997, along with a provocative Gleaner editorial. The current president of the UK Supreme Court and the Judicial Committee of the Privy Council felt compelled to write a letter to the Gleaner editor, indicating that the Privy Council was here to serve Jamaicans. In his formal virtual lecture here at the Faculty of Law, Lord Reid indicated the court was very pleased to be invited to sit in Caribbean jurisdictions in persons. He also indicated that he wanted to have a judge with direct experience of local conditions to sit on the Privy Council. And the eminent former Chief Justice of the Eastern Caribbean Supreme Court, Dame Janice Pereira of the BVI, has recently been so appointed. I'm not going to analyze those exchanges here. Much has been said about them in different fora. I just want to say something about the affective terrain of this remarkable dialogue over the last few months. The question we should be asking today is, are we loitering, or is lime we liming? Or is check we are check long distance? Or are we making sport in the long durée of decolonization? I refer to these rhythms of our last 60 plus years as the intimacies of decolonization. We think of decolonization as a breakup. Well, decolonization actually generated new entanglements between the colonizer and the colonized. Just think about the intense political negotiations between nationalist politicians and colonial officials, copious constitution making with London constitutional conferences. When Lord Diplock arrives in 1975 in Jamaica, across the road at the Norman Manley Law School, he says it's as if he was having a reunion with his Caribbean peers who had been trained similarly. Well, these intimacies are sustained as the Privy Council visits the Caribbean, as Caribbean lawyers travel to London, as UK barristers develop specialized practices in our law, appear in our cases, awkwardly speak our language as they repeat our evidence, and whisper between the benches to their Caribbean counterparts. These acute intimacies persist in the context of what I call the dyadic constitution, in which the formal or large C constitution references is entangled with and may owe its existence to an external constitution that is British and in good measure imperial. Imperial laws and policies provide the scaffolding for Caribbean constitutions, whose infrastructure interpolates British institutions in Caribbean governance, the Privy Council, His Majesty and his representatives, the UK government, the Parliament. Notably, the Privy Council became a much more powerful court in the Caribbean after 1962, because then it became a supranational constitutional court with judicial oversight of our new constitutions and our constitutional change. We have long noticed that Anglo-Caribbean constitutions are durable, unsure what to make of that. I very much like Anne Laura Stoller's parsing of the word duress in her recent book, Imperial Durabilities in Our Time. She uses duress to capture both the idea of endurance and constraints. In several respects, to different degrees, or so-called decolonization constitutions have strapped us in to an imperial straitjacket. We indulge, in the meantime, in self-flagellation, pathologize ourselves for struggling to get out, without reflecting on the fact of and the nature of these constraints that have contributed somewhat to the long durée of decolonization. When Dick Renee talks about the difficulty of direct democracy referenda, and she's thinking in the context of Grenada, which often requires consensus and compromise, when the very constitutions have entrenched a polarized political party system. So you might ask, aren't these arrangements we agreed to, that we wanted? Well, to some degree, probably yes. But the processes leading to these constitutions were conducted in ways that can't easily tell us how we ended up with what we have. William Dale, a legal advisor to the Commonwealth Office, boasted of 33 independence constitutions drafted in London by Whitehall lawyers. He spoke with considerable agency about the constitutional weavers in the London Colonial Office, whose tailoring, he says, was often a matter of scissors and paste, reproducing in the Caribbean British systems of government, implemented what were long-established British policies. Spencer Morby describes the hostility between nationalism and late imperialism, and the imperial distrust, sometimes clear racial contempt, which shadowed the making of these new constitutions. He describes a satirical exchange in 1962, now available in the declassified internal Colonial Office archives. There was an exchange between Colonial Office officials about what the motto of the dead federation might have been, in which the head of the Colonial Office, the permanent undersecretary, suggested, and I quote, 10 little nigger boys. An international lawyer I know always reminds me that self-determination is a right in international law. It's not a favor, it's not a gift. Worse yet, a gift with conditions. I think of a Caribbean common law giving us an opportunity to step back from the 1-1 referendum and appreciate the quality of endurance and duress that now mark the long durée of decolonization. We must look more closely at the Emperor's Close as we hope for constitutional change. In ending, so what is the future of a Caribbean common law? I think the future must be more outward-looking, more curious about the universe, beyond our common law kinship. But let me say, I'm far more nervous about the fact that we might continue to dig into an unmoored identity as what I've called post-past it people. People who say they are all past it. I am less concerned about the numbers, 10 minus 1, 5 leaving 7, and so on. If we look again, if we give careful and just attention to a Caribbean common law, we find in our present constitutional intimacies that we have misrecognized, that have left us highly self-critical of our Caribbean bodies and incurious about the durability and pressure of our imperial garments. If we exercise a moral discipline of the mind, I think we'll find in a key past moment questions, to borrow from David Scott, that are still worth having answers to. I think we find in the middle calls to us which have been answered, to which we have answered with a response. It is in the vibrant dialogue about how we come over. If we can come over, should we come over? Who now come over? Which part we can consider come over? That I see a future for a Caribbean common law through those pedagogies of crossings. I end tonight by remembering Suzanne, she who is not here. But I, like many of us, am here because she was. Thank you, Suzanne. Thank you all very much.
Tracy, I'm feeling like a student tonight. Thank you so very much, Professor Robinson. I certainly think you have honored and done more than justice to the fine tradition of the inaugural professorial lectures in the Academy. Thank you so very much. And I'm certain that you have provoked so many questions and so much thought in the minds of our audience. Ladies and gentlemen, I invite you again to applaud her. So I'm obliged to bring the proceedings to a close at this time. There's a host of persons internal to the faculty and internal to the university whose work and whose assistance and whose support have been critical and indispensable to this event. I acknowledge them. They are identified on the back of the program, and I wish on behalf of Professor Robinson and the faculty to say how appreciative we are of the long hours you've all put in and how grateful we are for your dedication to ensuring the realization of this event. I wish too to express my gratitude to you, our audience, for attending, whether you are here in person or online. We really value your interest in the work we do in the Academy, and we thank you for your ready and enthusiastic support of this inaugural lecture by Professor Robinson. Sincere appreciation for your attentiveness and the generous congratulatory messages you've communicated to Professor Robinson. I thank you on her behalf. And although this part of the event is at an end, I invite you to linger a while and have cocktails, which are being served in the courtyard just outside of this lecture theater. This is a good opportunity to have a chat and catch up with Professor Robinson. It remains for me, really, to wish you a very good evening. Thank you very much.
To face a world of challenges to conquer.